there were some very disturbing reports that have recently come to light that have suggested an outcome that, if proven, could really blow this case wide open and would force, in my opinion, a retrial. Martin's confession, which was the only thing that really put him in jail without a trial, was not only coerced and manipulated, but it was obtained through a dedicated and premeditated campaign of torture. And I mean physical torture. I will be presenting evidence of this to Amnesty International and to human rights lawyers and following up on this. It is some of the most serious allegations I have heard. Welcome to the Wasp Files. Some of this material may be distressing, and viewer discretion is advised. Thank you for joining us for this episode of the Wasp Files. Feel free to share far and wide and see the attached files in support of the episode. Thank you. This episode of the Wasp Files will present a departure from the usual discussion examining the many anomalies, discrepancies and circumstances of the shooting and the people involved. I would like to talk about specifically about the legal improprieties, the lack of due diligence and failure of judicial process of the crime and the consequent incarceration of Martin Bryant, the convicted perpetrator. The first thing to state is that once again, this was the biggest mass killing by a lone gunman in world history. A major level crime that shocked the entire world. By law, and really by just the simple fact of the nature of that crime, there should have been a coronial inquest to determine the circumstances of the crime and the manner in which people were killed and how it occurred. This was commenced, but it was abandoned. In essence, it was quashed. The coroner at the time, Ian Madison, had commenced a coronial inquest into the Port Arthur Massacre, but it was abandoned after pressure from the then Prime Minister John Howard. And the same with Premier Ray Groom. He had also reported that there wasn't going to be a coronial inquest. The first that victims and survivors had heard about it, they assumed there would be an inquest, was that they received a letter from the coroner, Ian Madison, stating that he would not be continuing the coronial inquest, particularly if his findings were inconsistent with that of the Hobart Supreme Court. Now that's a very unusual thing to say, because by law, if there is a determination of guilt, a state coroner, can discontinue a coronial inquest, but the manner to which he communicated that was that he may have findings that were inconsistent with that of the Supreme Court. So if the Supreme Court had determined that Martin was guilty, in essence, the coroner, Ian Madison, was saying that his findings may not reflect that determination. By all responsibilities, morals, and the requirements and even demands from the survivors, particularly in relation to the major work health and safety breach of the locked fire exit door, there should have been a coronial inquest. 7 people died as a result of the fire exit door on a government-run tourist site being nailed shut. That alone should have mandated by law a coronial inquest, and we didn't have one. A sister to a coronial inquest, though of somewhat greater proportion, is a royal commission. Australia has had many royal commissions in the past. Being part of the Commonwealth, a royal commission is in essence a public inquest into a major event, which has very wide reaching and broad powers to determine in great detail the circumstances and determinations of an event. It is a rare thing to have a royal commission, but it does occur. This, of course, in my opinion, certainly mandated a royal commission to look at how such a catastrophic loss of life could have occurred at Port Arthur. And this didn't happen as well. So that leaves the aspect of an open trial. An open trial where evidence can be presented, where the accused can be cross-examined vigorously, where motivations can be determined, where witnesses can be called first-hand, and there were hundreds of those, all to give their testimony and to determine the guilt or innocence beyond reasonable doubt in a court of law. As is often stated, but sometimes not practiced, you are innocent until proven guilty in a court of law. So, why didn't we have an open trial? There are some reasons for why we should have had a trial, and there are reasons why we didn't. Before we get to that, let's look at some of the facts that would determine a lack of due diligence and abandonment of judicial process. The first was that it's commonly regarded that Martin Bryant was of low intellect, that he had an IQ of around 66, which makes him, in essence, an 11-year-old child. So if you consider that you've got a child in a man's body, despite the heinous nature of the crime, you have a child. There is some question as to whether or not a child can be charged, convicted, and to be able to give even testimony in a court of law that would be of an adult nature. Further to that, in 1993, 3 years before the Port Arthur Massacre, Martin Bryant was placed on a guardianship order by the Hobart Supreme Court of Tasmania, rendering him mentally incapable of managing his affairs, whether they be financial or otherwise. So it was considered by the court that he was not able mentally, in a disadvantaged state, to be able to handle his affairs. So some of the money that he inherited, for instance, was then placed into a trustee to be able to, control his expenditure and so on. But what you've got is a formal determination by a court of law that this is a person of low IQ with a mental disadvantage. So that's the first issue, is someone in that state, you would think, would not be able to issue a plea of guilty or not guilty in the first instance. And yet they were determined capable enough to be able to issue a plea initially of not guilty. For 5 months, Martin Bryant held staunchly a not guilty plea, and then after 5 months in solitary confinement, he changed his plea to guilty. So the only thing that put Martin Bryant in jail was his guilty plea. That also negated the need for a trial, and so there was no open trial. The problem with that is that in not having an open trial, there was no way we could see evidence and hear from witnesses that would contradict the mainstream story and the police reports. So Martin pled guilty. No need for a trial. But why? Why did we not have an open trial? Why could we not have an open trial when really we should have? One of the reasons was that after the event, literally a day after Martin Bryant was arrested at Seascape Cottage, and yes, he was there, he was found there, someone broke into his house at Clare Street in Newtown and stole a photo of Martin Bryant, which then appeared on the front page of all the major newspapers with headlines like, "This is the man and the face of a killer." Now, not only is the theft of the photo illegal, but the printing of his photo in the papers and the determination, the predetermination of his guilt, he hadn't even been charged, is highly unlawful and did absolutely prejudice any notion of a trial. So Martin hadn't even been charged, the circumstances of the crime had not in any way been determined, and the papers took it upon themselves, the press, to basically determine that he was guilty. That is unlawful, and a good lawyer straight away would have said, look, this prejudices an entire trial, which it did. As a result, I believe that Martin Bryant's defence attorney, John Avery at the time, John Avery replaced David Gunson, realised that you couldn't have an open trial because straight away it's been prejudiced by the media. The media was slapped across the wrist for doing what they did, but there was very little consequence for that action. But that is a major breach of a legal judiciary process, and yet it occurred. There was a pre-trial hearing, and at the pre-trial hearing there was evidence that was presented by the Chief Prosecutor, Damien Bugg, including a transcript of a police interview that Martin Bryant had given months after he had been incarcerated at Risdon Prison. The interview was held by Inspectors Payne and Warren and recorded. One of the legal problems with that particular interview was that at the very beginning of the interview, Martin was questioned and he replied, "Shouldn't I have my lawyer present?" And the response was, "Oh, he knows about this." And then Martin continued giving an interview with Inspectors Warren and Payne. Now, what you've got is a person with a 66 IQ and a court-appointed medical disadvantage giving a police interview without legal counsel present. I'm not a lawyer, but in my opinion, a good lawyer would have said that that entire interview would be inadmissible in court because there was no legal counsel provided. The other issue with the interview is that when it was read out in the pre-trial hearing, 65 pages were redacted. I've got the unredacted transcript, and that is available as part of the files on the Wasp Files. If you go to the Dropbox file and also the Facebook page, you can download the unredacted court pre-trial transcript. If you compare them side by side, they are markedly different. Not only does the unredacted transcript provide far more detail where Martin Bryant constantly says, "I do not recall, I was not at Port Arthur." On multiple occasions he states he was not at Port Arthur. He also makes a statement that in essence he was physically maltreated, that they had twisted his arms up behind his head. Martin was burnt at the time from the Seascape fire and was basically complaining that the handcuffs were put very tight on him, they were cutting into his wrist, and that he was made to lie down on his burnt back. Now, that in essence constitutes a serious case of maltreatment, and I'll go further on that later on. And that was not read out in the pre-trial hearing. If it had, once again, a good defence lawyer would have said, hang on, this person is claiming that they were physically tortured in essence. So that would certainly cast some aspersions on what was stated in interviews. Unfortunately, that was not read out in the pre-trial hearing. With the police interview that was conducted without legal counsel, there were some other issues. One of them was that, technologically, things weren't as sophisticated perhaps as they are nowadays. However, there were technical issues with the recording of the interview with Martin Bryant. As a result of that, some of the testimony was illegible, and the transcribed versions don't have any clear determination on what was said. It was, communicated to Martin that there was a problem with the audio recording equipment or the video recording equipment, and that resulted in the tapes having to be stopped at certain points and glitches. So, a good lawyer would have looked at that and said, look, you've got some problems here. How do we know that the tape wasn't stopped and things were said and so on? So the quality of the interview itself wasn't superb at all. In regards to Martin's testimony during that interview, It was played at the pre-trial hearing as, in essence, evidence that he was involved in Port Arthur and committed the crime. There's only one problem with that. Martin, during the entire transcript, including the redacted version and the unredacted version, firstly, never once admitted to killing anyone, nor did he admit to being at Port Arthur at the historic site. He admitted to owning some of the firearms, but he claimed that he had never seen the FNFAL. And the only, in essence, admittance, if you like, of his involvement with the crime was that he had a confused recollection of kidnapping Glenn Pearce, who was one of the victims that was killed. He was taken hostage and later killed in the fire at Seascape. He gave testimony that he had kidnapped Glenn Pearce at gunpoint because he wanted to steal his car, put Glenn Pearce in the boot, driven to the Seascape cottage, and his only recollection of what had happened was that there had been an explosion, a fiery explosion, and that's how he had gotten burnt. So, as suspicious as that may sound, never in that testimony did Martin Bryant admit that he'd shot anyone. It's a confused recollection of why he would have been involved or there at the time and why he was at the Seascape cottage. He did not admit to killing the owners of the cottage either. And what it requires is that then he would need to be cross-examined to say, well, hang on, you're at Seascape, what happened to the elderly owners, what happened to Glenn Pearce's girlfriend who was murdered in the passenger seat next to Glenn Pearce. But that was never allowed to be determined in a cross-examination in an open trial. So the recorded interview with Martin Bryant, seemingly guilty as it makes him, is not enough to convict, in my opinion. Once again, I'm not a lawyer, but there's no confession there. The only thing, and most people point this out, and it certainly does appear to be a damning thing to say, is that right at the end of the interview, Martin states, I hope you find the person responsible for all this, and then points at himself silently and mouths me. So you could say that's it, he's actually admitted, but he actually hasn't admitted to any particular crime. He said he was responsible for this. Legally, an argument could have been held that during that whole interview, Martin was kind of frivolous and laughing and acting very inappropriately, as he's been known to do on many occasions, whether that's due to some condition that he has mentally. I know that people who have Asperger's can often respond very inappropriately to certain events that people find, distressing. They might laugh, whereas something else is people would find something distressing. His mental state hasn't really been determined comprehensively. I've got all of the psych reports. They are also available if anyone wishes to download and read them on the Wasp Port Arthur Facebook page. There were links to that. And it's his behaviour during that interview just seems to be a sense of unreality, that it's treating it almost like it's a big joke. At one point, he's told that there was a lot of people shot down at Port Arthur, and his response was, oh, they weren't killed. And you would think, well, that's a very unusual thing to say. Obviously, if he had committed those crimes, he would know very clearly that he'd shot people. And then when he had no idea of how many had been shot, when he was told 35 people had been killed, his reaction was genuinely shocked. But he never admitted to it himself. So I think that the interview, as unusual and potentially damning as it seemed, need to be put under a cross-examination, and never was. And to this day, Martin hasn't been interviewed by the media 29 years later, or if there has been any further forensic examination, it's come through psychologists that have spoken to him. Even John Avery has basically come out, his defence lawyer, and said Martin, was confessed that he did it and why he did it and so on. But given the nature of John Avery's so-called defence of Martin Bryant, I think that has to be taken with a grain of salt, because in my opinion, John Avery didn't provide a very good defence at all of his client. He convinced his, this is covered in a former episode about John Avery, that his response was not to even go for an insanity plea or to question the legitimacy of the media leak or the failures of the lack of legal counsel, but to go to Martin's mother, Carleen Bryant, after 5 months and basically manipulate her into going to the prison and saying to Martin, unless you change your plea to not to guilty, you will never see me or your sister Lindy again. So the consequence of that was that Martin had changed his plea to guilty, and that negated the trial, and away we went. Now, this is Martin's defence lawyer. He's supposed to defend his client. Even if he believes he's guilty, he pretty much, in my opinion, hung him out to dry. You can disagree with that, but there was no vigorous defence of Martin Bryant. There was no, full and publicly accessible determination of his motivation, his mental state. He's never been diagnosed as being a psychopath, as having dual personality. It's 50-50 whether he had schizophrenia or whether he didn't. There's conflicting reports of that. And this person, as we know, was mentally disadvantaged. Should have had a full defence and, perhaps a push to at least find him not guilty by reason of mental disadvantage or by insanity. And that never happened. He was tried by his confession and put in jail, and there's never been, anything to determine otherwise. I mentioned earlier that there were some very disturbing reports that have recently come to light that have suggested an outcome that, if proven, could really blow this case wide open and would force, in my opinion, a retrial. We have had a statement on the interview that Martin conducted with Inspectors Warren and Payne, where he stated that he had his arms twisted up behind his head and that the handcuffs were too tight, and that in essence he was maltreated. I have since compiled quite a lot of circumstantial evidence that's quite strong from people in the know that Martin's confession, which was the only thing that really put him in jail without a trial, was not only coerced and manipulated, but it was obtained through a dedicated and premeditated campaign of torture. And I mean physical torture. I will be presenting evidence of this to Amnesty International and to human rights lawyers and following up on this. It is some of the most serious allegations I have heard, and despite the nature of the crime and whether or not people can hate someone if they believe had carried out something as horrible as Port Arthur, this is Australia. We don't torture people while they are incarcerated. I will just superficially go through some of these. I have spoken to people that were ex-employees of the Risdon prison. One of these I will call Peter, who stated that Martin Bryant was handcuffed to his wheelchair and wheeled in under boiling water in a shower, and, quote, you could hear the screams through the cell block. I have had other guards inform that, former guards, that he had boiling water poured down his throat, that he was beaten quite regularly, and that there was another former female associate with Risdon Prison who stated that a lot of the guards were very cruel, and that I'll call that person Al, and she said that she'd sort of gotten to know Martin and that he was quite a sort of timid, sort of frightened type of person, and that she would she was inspecting the cell one night and couldn't see him in the cell, and communicated this to the manager, and they said, "Oh, don't worry, he's curled up on the floor at the end of the bed because he's afraid that he could be shot through the windows of his cell," and that guards would laugh at that, and they would communicate to him and say, "Oh, look, we can still get you even though you're on the floor," and would shine red lasers at him, like pinpoint lasers, which are the sort of thing that a laser-sighted weapon is often attached with, to be able to pinpoint a target. Guards have departed from Risdon Prison due to the institutional nature of the violence that was carried out there. And in 2015, ironically, Risdon Prison was subject to its own coronial inquest due to the deaths of inmates that were incarcerated there, suicides, and virtually a total lack of mental support for people that were suffering from mental conditions that then resulted in their suicide. Also claims that there was a trans inmate who, basically determined that her gender was that she was a woman, and she was housed with male prisoners and was raped, gang raped. What I've heard from Risdon is that it is a black hole of a prison, and that the sensibilities of the old penal colony of old are alive and well down in Tasmania. Whether or not that has been rectified now, we certainly hope so, but I do understand that there are some very nice people working there, some very helpful guards, and that there are some that are not so helpful. It is a dangerous and potentially life-threatening place to be incarcerated in. I will be presenting far more formal evidence relating to the specific torture, including names of the people involved. And if this doesn't force some kind of retrial or reopening of the crime, I don't know what will. Thank you for joining us for this episode of the Wasp Files. Feel free to share far and wide and see the attached files in support of the episode. Thank you.